Well, of course, the asset protection angle comes from the anonymity. Since you are the owner, the investor is the owner of the trust, the beneficiary. Your name does not appear on the public records. So if you're in a car accident or if you breach a contract and you get sued, if that lawyer starts searching for assets that you own to see if you're a deep well, a deep pocket, they're not going to find your name on the public records of real estate. So it looks like you don't own anything because the trustee's name will appear, not yours.
This episode brought to you by Suites at Madison. Meeting and conference rooms for rent by the hour, week, month, or year. Suites at Madison, where business gets done. Check them out at www.downtowntampaoffice.com. Now, on to the show.
You are listening to the Invest Florida Real Estate Show, covering topics in lending, buy and sell strategies, property management, hot markets, and tips and tools to guide you along the way on your path to real estate success. You want Florida investment real estate talk? You have come to the right place. And now, our hosts, Eric Odom and Steven Silverman.
Hello and welcome to another episode of the Invest Florida Real Estate Show. This is your co-host, Eric Odom, along with Steven Silverman. Steven, we survived another hurricane.
We certainly did, and it was a little bit different for me this time because I decided I'm not evacuating and just stayed and powered through it.
You're on the Bay Shore in Tampa, and I never really did ask you how much water intrusion on the Bay Shore was there?
Well, enough to have like boats going past on the Bay Shore, like people paddling and canoes, and it was really quite a lot of fun. I mean, but we didn't lose electricity. We didn't, which is always the big thing. And people who were smart, like just moved their cars to higher land, and we got through it fine. But, we got lucky. And Tampa keeps dodging a bullet because it's been to the south, it's been to the north. It hasn't quite hit us head on yet.
They said it's the Indian burial mounds.
Could be. You got to believe in
Indian burial mounds apparently keep all the storms away from the area. I don't know.
These theories start popping up, right?
Yeah, well, I mean, obviously we didn't get a direct hit from the wind, but these hurricanes, people see them on the radar. It looks like it's just the entire state. Everybody in the state's going to die. So it's we get 2 or 3 of these every year, and friends and family outside of the state all start sending, messages to me, get out now before they find you 30 miles offshore. I've been through, I don't know how many of these exercises, these drills. Hurricanes are pretty small, really. Their hurricane winds are within a fairly small radius, and it might look like on a radar it's covering the whole state, but that's just cloud cover. But it does push a lot of water, and that's the big issue in the Tampa area. That storm came close to us, and then it moved in over Florida, which sucked a lot of that still fast-moving air over the bay and pushed a lot of water up onto Bay Shore Boulevard and to South Tampa and places in Pinellas County too. It's the nature of the beast. But I think this was one of the worst ones I've seen in terms of how much water it sucked in. And it really had to do with the angle that it came in, right? And it was still fairly powerful. It was north of us. And then all that moist air that was getting sucked up from the Caribbean, from the Gulf, got pushed up into the Gulf of Mexico. And that's where the flooding comes from.
Yeah, so the real issue is what you just said. Like last year, the hurricane hit south of us and it devastated Fort Myers. But because it was south of us, the direction of the wind flow actually pulled all the water out of Hillsborough Bay.
Right, correct.
This year, because it was north of us, it pushed all the water into Hillsborough Bay.
That's right. So people were literally walking across the bay last hurricane, finding artifacts from 100 years ago. I mean, people are just walking their dogs out in, where there's usually 6 to 8 feet of water. It's so crazy. I mean, the storms are crazy. Of course, we did not an article, but a podcast about this, I think 2 episodes ago, Stephen. We talked about the insurance. And of course, that's the big thing that affects real estate, right? Insurance is definitely adversely affected by hurricanes, but we learned in that episode, if you want to hear more about it, it doesn't have everything to do with the hurricanes. In fact, the primary driver was political.
Absolutely. I mean, you look at places like New Orleans, they actually fare worse than Florida does, and they don't have insurance rates climbing like we do. Insurance was poorly managed in Florida, and that's the reason.
Yeah. The legislative part of the insurance industry has done a really poor job. And regulatory and legislatively, they've done a really poor job, and it's tough because the insurance companies don't want to operate in the state, and that's a big problem for us in the real estate industry. There was the laws were passed. Again, if you want to go listen to all the specs on it back in March, I think. They passed some laws that were supposed to alleviate some of that. We've not seen it yet, but until they address the reinsurance issue, it's not going to completely get rectified. And even then, we've got the increase in storm activity that is going to keep it from going back to the rates that we saw years ago. So it just is what it is.
Somehow prices never go down, Eric. They just seem to go up.
Right. That's right. So talk about something a little bit different today. We're talking about really asset protection issue, among other things. And we've discussed this before, land trusts. We discussed, I think maybe 2 or 3 years ago, we talked about it. But this is a little bit different because we're going to talk about the things that people don't know about land trust that are the most important aspects of it. And we really just focus on those aspects. So if you've not heard about land trust, it's something you definitely want to listen to our speaker today and see what he has to say. Stephen, any housekeeping issues that we want to cover before we roll into our guest?
Yeah, I think one of the things we would ask is when you listen to a podcast, if you could leave a review. Those reviews really help us. It helps us get new guests, and that's what helps keep the show entertaining and knowledgeable and informative for all of us.
100%. You know, guys, if you've not left a review, it's really important. Please do. This show takes a tremendous amount of time and energy, and to try to get quality guests that you want to hear on the show, they'll go to look at the reviews to see who's listening and who's paying attention. So everybody wants to invest time where they think they're going to get the biggest investment. So those reviews help the guest understand that this is time that's well worth investing in. So, if you haven't done it, please do it. And if you have done it, we really appreciate you. And anybody who's listening, we appreciate you anyway. I'm Stephen, and I do this out of a labor of love. We don't make money off of this. It's not. We don't to monetize it. And it's really just something that we enjoy listening to the guests and learning about the real estate business. We learn something every day. I mean, I've been in it for, my gosh, it's almost 40 years, Stephen. 37, 38. No, it's not true. That's not true. I started out as a banker, and then I did some other things, and I came back. So as in real estate, I've been in it since it's been 20 years as a retread in real estate. And I know you've been in it for at least 90.
94.
94.
Yeah. But who's counting?
Who's counting? That's right. Okay, so let's go ahead and roll into our guest.
Today we have with us Joe Seagle from the law firm Joseph E. Seagle, PA. Joe is a legal GPS for the real estate and hospitality industry. His firm works with clients, helping them to discover where they are, where they want to be, and how to get there legally. The firm does this by assisting clients with the purchasing, protecting, and passing on of assets vital to financial independence. Under one roof, Joe has assembled a law firm and a land trust company that can act as a central source of information and service for clients in pursuing their goals. The firm's representation is concentrated on real estate investors, developers, brokers, property managers, hoteliers, restaurateurs, private lenders, and for their needs regarding land trusts, private lending, and equity and entity formation. Joe has been practicing law since 1996. He has been licensed in Florida, North Carolina, South Carolina, and the District of Columbia. He is also a licensed Florida title insurance agent and a real estate broker. His company, My Land Trustee, holds title to over 2,000 Florida properties and trusts to maintain owners' anonymity. Joe, welcome to the Invest Florida show.
Thanks for having me.
Hey, Joe, really appreciate the time that you're investing with us today. We've had land trust discussions in the past, but we continue to get questions about folks that don't really seem to understand land trusts and what they can be used for. So we're going to take a little bit of a different angle on this today. We're going to talk about maybe 5 uses of land trusts so that hopefully we can touch on some of those topics that might ring a bell with somebody in terms of why they would use it and when they would use it. But again, we appreciate your time, Joe.
Yeah, my pleasure. Yeah, I think the number one thing that especially real estate investors think of is of course, the anonymity, the asset protection aspect of land trusts. A lot of people in a lot of other states will form an LLC to hold the property or a company to hold the property. And in Florida, we're lucky that we have this wonderful land trust statute. And under the land trust statute, we can quickly, cheaply form a trust with a trustee, beneficiary, trust agreement, a deed, and you're done. And you've got the trust that now holds the property. It's separate from everything you own. Only the trustee's name appears. We're not like a lot of other law firms. A lot of law firms will set it up to where they'll set up another company for you to be your own trustee through that other company. We don't do that. We actually have the company that will act as a true arm's length third-party trustee to keep your name off the records. Our name is what appears. And it also separates that one piece of property from everything else you own in the county. So if you get code enforcement violations or anything like that on this property or any other property, it's not going to affect your ability to sell this property or refinance this property when the time comes. You can go ahead and do whatever you need with it, and it's not going to be affected by whatever bad things may be happening at your other properties.
Why don't we start with sort of the primary reason, well, not primary because there's other reasons that you would use a land trust, but the one that most people are most familiar with, and we're going to talk about 5 ways to use land trust today, but the one that folks think first when they think land trust is the asset protection, and that it provides, people will get into a land trust, and many times they'll have an attorney that will say, hey, why don't you do a land trust? It offers some asset protection. And why don't you talk a little bit about that and what they mean by that? So that's going to be one of the 5 topics we're going to talk about today in terms of what, from an asset protection standpoint, what it actually does.
And Joe, maybe at the same time you can answer, because almost everybody goes out, and I would think the majority of people form LLCs, like why it might be an advantage to have a land trust instead of an LLC.
Those are both really good questions. Well, of course, the asset protection angle comes from the anonymity. Since you are the owner, the investor is the owner of the trust, the beneficiary, your name does not appear on the public records. So if you're in a car accident or if you breach a contract and you get sued, if that lawyer starts searching for assets that you own to see if you're a deep well, a deep pocket, they're not going to find your name on the public records of real estate. So it looks like you don't own anything because the trustee's name will appear, not yours. So that's number one. Number two, you typically put each property in its own trust. So if you're a real estate investor and you've got 3 or 4 properties that you're rehabbing and 2 or 3 that you're holding as rentals, you will want to put each egg in its own basket, so to speak. So if that basket falls, that egg breaks, but not all your other eggs. So if something happens at one property, it does not affect all of your properties. If something happens with you, it doesn't affect your properties. If something happens at your properties, it doesn't affect you. Now, the reason a lot of people will, in Florida at least, shy away from an LLC, a couple of reasons. Number one, LLCs are more expensive typically to form and to create. They're handled at the state level. So someone's name typically goes on those records at SunBiz. A lot of people know about SunBiz, B-I-Z. And if anyone wants to search your name to see what you own, to see if you are a deep pocket, they're also going to search SunBiz in addition to all the county records to see what you have. And your name's going to pop up on that LLC as maybe registered agent, maybe as a manager. And that's going to raise some questions of, well, maybe you have some assets that we can take, that if you don't have enough insurance to pay my client for their damages, at least you have property. And we are often called on cases like that where they are searching for assets, and they will contact us to help us find assets. If we're not the trustee or if we're not involved, we're called in to see if we can root out something that someone owns. So it is very common that they're always looking for a deep pocket where they can satisfy their judgment. And with an LLC, your name's typically going to show up. And if it doesn't, you may be a little too anonymous, and I've written about that in the past. Sometimes a little too much anonymity with real estate is actually not a good thing. So I'll leave that at that.
So just a question on that, though. An LLC also sits just by itself. So if the whole idea of the LLC is that they can't reach into something else that you own because the LLC is protecting and standing by itself.
Well, they can look you up by name.
Right. I understand they can find you, but they can't. If something happens in one LLC or another LLC or in your name personally, can they attack the LLC that holds your property?
Well, they could. Well, you're assuming that you form one LLC for every single property, and in states where we don't have the land trust statute, a lot of times we fall back to that. That's exactly what we do. We say, yeah, we'll have to form an LLC for this property and this property and this property. Each one has its own LLC, which gets expensive because they're typically more expensive to create on the front end. They are also going to have, they're going to need their own separate bank account, their own tax ID numbers usually, their own tax returns. And with a land trust, everything is disregarded, passes through. So you could still have an LLC that is your beneficiary. And we do this with a lot of real estate investors. You may have two LLCs. One LLC is your buy and hold LLC. The other LLC is your dealer, your wholesaling, your flipping LLC that does not hold property very long. Once you're going to flip, that LLC will be used as the beneficiary of multiple trusts, each trust that owns a property, and buys it, fixes up, flips it. That all passes through to that one LLC. The buy and holds all pass through to your buy and hold LLC. So in a way, you get away with just having two LLCs instead of, if you have 20 properties, having even 10 LLCs or even 5 LLCs. And because we have that too, a lot of people try to save money. So they'll form, well, I'm going to do one LLC and I'll put 5 properties in it. Well, you've still thrown 5 eggs in one basket. So if something happens, you've lost 5 properties instead of just one. So that's why we typically in Florida, where we have this mechanism, we definitely advocate for the land trust instead.
I was going to say the other thing is that what I've seen with LLCs is that people don't maintain them, and just filling out your SunBiz forms every year with the Secretary of State doesn't necessarily mean that that's a legitimate entity, and they'll pass through the LLCs because they're not having their annual minutes and all the other things you have to do to maintain. How real of a problem do you think that is on the LLC? And then is it easier on the land trust side to maintain?
True. We see that a lot. In fact, I had to file 2 LLCs earlier last week where a gentleman had failed to file the annual reports in time. So and that's March 1st or May 1st. Hard cutoff. You don't file. Now it's a $400 late fee, which Florida has one of the highest late fees in the nation. For us, and it's also $138.50, I believe, is the renewal fee, or $138.75. I can't remember which. For us, it's $100, and each year you pay us $100 if it's in existence for another year beyond that. But the thing is if it's not like if you don't pay our bill, we're immediately deeding it out to you that day. I mean, a lot of times we just let them ride, and yeah, you're running a late fee on your maintenance fee bill for us, but it's not $400 if you missed it.
You're talking about the land trust or the LLC?
For the land trust.
For the land trust, correct. Yeah.
Yeah.
Okay.
Yeah. So yeah, we charge $100. The state charges $138. for renewing an LLC. So we are cheaper in that regard, and we're not as draconian that if you miss the deadline of paying our bill, you're not going to have a $400 late fee like you would with an LLC.
Understood. So that was number one, is asset protection. That's the one that most people, when they think about land trust, they think about. Why don't we talk about lending money? You mentioned that, and I was like, wow, that's something I didn't know about. So why don't we talk about lending money?
Yeah, we represent a lot of private lenders and hard money lenders from all over Florida, lending to real estate investors. And we found a couple of uses for the land trust. Number one, we often find that there are multiple lenders coming together. They're pooling their money to lend to this investor. It may be 2, it may be up to 5. I've had them up to 6 lenders on one deal before. And that gets unwieldy on the mortgagee line of 5 lenders, one at 5%, one at 90%, one at 1%, one at 1%. It gets unwieldy to put all of that in. So, and also, if you ever go to foreclose, all of those lenders in their percentage interest are named on the lawsuit as the plaintiff. And if any of those lenders happen to be IRAs, self-directed IRAs, they have account numbers a lot of times, and they're going to be listed on the foreclosure complaint as well and all the other documents. And I can tell you that's really going to slow down the foreclosure, because every time you file something, the clerk has to get a special form to tell them to strike out the account number. So it gets unwieldy. So what we do is we form a special land trust. We call it our mortgage holding trust. And that special land trust, then all of the lenders are the beneficiaries of that trust in their percentage interest that they would normally be listed as the lender or in the lenders on the mortgage and the note. And so what we do is we say we have a land trust company that does nothing but hold mortgages for lenders. And so we are listed as the mortgagee. We're listed as the holder of the note. If there's a foreclosure, we are the plaintiff as the trustee of the trust that held the mortgage. And that's it. It keeps it really simple for foreclosures. It keeps it really simple for the lenders as well. Another thing that we can do, a lot of our lenders, what they do is they'll have a special land trust, even if it's just one lender. And that lender will be listed as what's called the primary beneficiary. And then the borrower is the secondary beneficiary. So in addition to the mortgage, you also have the land trust. And inside the land trust, it says if the secondary beneficiary borrower defaults under the note or any other terms of the loan agreement, then the primary beneficiary immediately takes over the trust. Well, the trust owns the property. So this is used for very special occasions. It's typically our hard money lenders for very short-term loans, and they will take title in this special, what we call the lender trust. Primary is lender, secondary is borrower. We still have the mortgage on the property to the lender. And if that borrower fails to pay, things go sideways, the lender can immediately say, okay, you've defaulted. The property's now mine under the trust agreement because I'm the primary beneficiary. I'm taking over. I tell the trustee what to do. And if I tell the trustee to sell the property immediately, they're going to sell it. They're going to get what they can get. I'll pay myself off. And if there's any money left over, I'll give it back to you as the balance. If the borrower balks at that, there's still the mortgage out there that can be foreclosed. But a lot of our hard money lenders will use that. And it really came in handy during the Great Recession because all of our lenders who held their properties in that way and held their loans that way, when the market tanked, just collapsed, came to a screeching halt in 2007, those lenders just went to their borrowers and said, hey, you're defaulting. I'm taking the trust back, and I'm going to change the locks on the house, and I'm taking it over. Only one out of dozens, one borrower objected. But all the other borrowers said, great, it's yours, take it. The lenders took the properties over, rented them out, made money off of them for a while. Whenever things got better in 2012, they finally sold the properties. and made enough to get back all of their principal plus some of the interest that they expected to make on the loan over the life of the loan. They were landlords for a while, but they did not have to go through a full-blown foreclosure. They didn't have to take a deed in lieu of foreclosure. They didn't have to do a full workout. It was all just handled inside the terms of the trust agreement, and they still kept a good relationship with the borrower. The borrower could pick back up in 2012 when the market picked back up and start borrowing again from lenders. So that's another way private lenders and hard money lenders will often use land trusts in our area.
So when you form a land trust, and with LLC, I mean, if you're using an LLC, you have to form the LLC before you acquire the property so you can take possession of the property. Does it work the same way with land trusts? I mean,
Yes.
Can you have a land trust with nothing inside it and waiting for a property, or how does it work?
We do have some clients who will open a land trust and throw one property into it just to have a land trust, because the statute, I was actually on the subcommittee with the Florida Bar when we wrote the last two major amendments to the land trust statute in Florida. And one of the things it says is that for a land trust to exist, you have to have trustee, beneficiary, trust agreement, and a deed into the trustee. So you have to have had at least one deed come into the trustee. Once the deed has come in, you've got it. So there are two ways we go about it. Most people never object, and we go ahead and form the land trust as of the date that the contract was signed, and there we go. We've got a land trust, and it's fine. We have had at least one attorney balk at that and say, no, your trust does not exist until the deed exists. So at that point with those, what we do is say, fine, the investor signs the contracts, negotiates the deal, gets everything signed. At closing, in the blink of an eye, they assign the contract to the trustee, and the trustee closes on the purchase of the property. Seller signs the deed into the trustee. Voila, it's done, and you're fine. But like I said, we've only had one attorney ever balk at the trustee signing the contract to purchase the property, because to me, it was splitting hairs, and we argued over that. But it was really that old argument of how many angels can dance on the head of a needle. It's totally hypothetical, and it didn't really matter. And we took care of it the way we typically do, and we closed, and we were the purchaser at the closing.
So we've covered so far money lenders. We've covered asset protection. Why don't we talk a little bit about estate planning and how it might fit into estate planning?
Yeah, land trusts, I call them estate planning light. They are not full-blown estate planning trust like you would normally consider a revocable living trust, where when you die, the trust speaks and says, okay, now she's dead, so this property will pass to this child unless that child has died, and then it will go to this grandchild, but then it's going to be divided up into this many parts, and the child will get it when they're 21 in this section, It doesn't go that deep. Land trusts, typically, we treat them as the real estate vehicles that they are. So since it's a real estate vehicle and not an estate planning vehicle per se, we use language associated with real estate. So we will have inside of our document, inside of our trust, it says this property, the beneficiary is Eric. And upon Eric's death, it goes to Stephen. So it's Eric for his life and then to Stephen. That's a life estate.
Can we change that around a little just for the purposes of
I was going to
discussion?
say, Stephen ain't getting anything from me. Now Tasha, his dog might, but Stephen ain't getting shit.
But that's about as deep as we go. We have a lot of people who go, well, if when I die, I want to go to my children. When my children die, I want to go to their children. When their children die, I want to go. And I go, stop. A land trust is not built for that. And it really falls under, it's very esoteric, very deep area of the law. And land trusts fall under Chapter 689 of the Florida statutes. Estate planning trusts fall under Chapter 736 of the Florida statutes. Totally different areas of the law, the way they're treated. So I use real estate language to make sure that there's not going to be a problem with who is going to get that property. And I always tell everybody, I go, look, we can go one level. So when one person dies, it goes to the next level, and that's it. We're going to stop there. And then after your death, then that next level, they're free to assign their beneficial interest to the next level for their life and then to the next. But if they really want to get into estate planning, we typically recommend that they go to an estate planning attorney, get a full estate plan done, and then their beneficial interest, rather than being held in their name or an LLC name, will be held in their revocable living trusts. And then that way it solves their estate planning issue fully. At the same time, it's solving anonymity and asset protection for them.
Okay, so we've got money lender, we've got asset protection, we have estate planning light. What are we missing here? Purchase price.
Yeah. Yeah, we can hide the purchase price.
And that's big. That's big.
Yeah. Yeah. I'd say probably on 60% of the closings where we're purchasing property or selling property, we are hiding the purchase price from the county records. And that's done by having the seller be the beneficiary of the trust initially. So it's deeded in, the seller is the beneficiary. In the blink of an eye, the seller signs an assignment of beneficial interest over to the investor buyer, and documentary stamp taxes are paid directly to the Department of Revenue on that unrecorded conveyance. So instead of going to the clerk of court or the comptroller, depending on the county, for the recording, the documentary stamp taxes are instead sent straight to the Department of Revenue on Form DR 228 or 219, depending on who the transmitter is of the money. And then it doesn't show up on the public records. It shows up as 70 cents, 70-cent transfer. And that just helps to let people know that it was a sale, but no one knows exactly what you paid for it.
Big deal with flippers. Yeah, big deal with flippers.
Yeah. That's what I was going to say. It's come in really handy with a lot of our investors who do a flip, and then it's an FHA buyer. And they don't know, on the record what they paid for it when they bought it. So they don't see how big of a gain it was. And this is what amazes me, and I feel so bad for investors, is they'll look at it and they'll go, well, you bought it for $50,000. Now you're selling it for $100 within 90 days. That's ridiculous. There's no way. And they go, yeah, but I put $40,000 in it, fixing it up. But yeah, we're not going to think about that. So just you keep the purchase price hidden to begin with. Make the appraiser really do their work when they come in to appraise it, not just relying on, well, you bought it for this much 90 days ago, prices have gone up or down by this percentage over that time. So if I praise it at this, I can't be wrong. Make them work for it.
Well, I think part of it's just natural human behavior. Like a buyer will look at it and say, I see what you paid for it. I'm not going to pay. I'm deciding how much profit you can make.
Right.
But if they don't know, they don't know. So is it too late to transfer a property you already own into a land trust, or is there any benefit to doing that?
It's not too late. You can always transfer a property into a land trust anytime you want to. And there's a whole litany of things we could talk about there. But it's the best practice to take it into trust when you purchase it, if at all possible, because you get the best bang for your buck there. Where we've typically had people want to move them into trust later is when they've got the crazy tenant threatening them with litigation. They've had a wreck, or they're about to be sued on a big contract default or whatever, and now they're going, wait, I need to get all my properties into land trust to get them away from me, so when I get sued, they'll be safe. And unfortunately, we have to tell them it's usually too late at that point. If there's ever been any threat of a lawsuit or any hint of it, whiff of it, it's too late to move it. So if you go ahead and just take it into the trust to begin with, at least that's your best bet. But again, and we've had some people who, politicians, they get elected or they get ready to run for office, and they go, look, I need to get all these properties out of my name, so people can't just look me up and find me.
You just know when you say politicians, something shady is coming next.
Well, and also, I mean, we've even had it with content creators, YouTubers. We've had it with professional baseball stars. You know, these kids are in high school and college and they're doing pretty well. And then all of a sudden they're going, hey, I'm going pro and I want to, buy my first house. And I don't want my fans to be able to follow me, or my parents. I don't want them to be able to find my parents. That's a big one. So we often hold all of their properties, their vacation homes, whatever they have in Florida, we hold them in trust to keep them out of the public eye.
I was able to track down Pitbull. I was working for working with a music festival in a volunteer capacity a few years ago, and tracked down Pitbull through his real estate holdings. And first thing I was thinking about, I called him a couple of times because we were trying to get a deal done with him, and his manager Willie wasn't cooperating, so I called him directly. And the second time he got kind of agitated with me. But the first thing that crossed my mind was, well, if you put your property in a land trust, you wouldn't have to worry about the Eric Odoms of the world calling you on your cell phone.
Yeah. Well, we had boy band members, back in the day, that girls would just flock to their houses when they found, even in gated neighborhoods, they would climb the gates and get in and just surround their houses because they could find them. And a lot of them they go, well, they had lawyers from New York or whatever go, well, we have to form an LLC so they can't find you, and we'll make some relative your manager. Well, they still found it. They looked up, they knew their relatives' names, and they found them.
Well, that's why we have extra security for the Invest Florida Show podcast groupies charging the front door. We had to hire an additional one last year.
We're waiting for people to break in. We've been waiting a long time.
Let's talk about subject twos.
Yeah. I'm actually going to be giving a class on this next week, that people buying property subject to the mortgage has become very popular because the interest rates on most mortgages out there are 3% or less. And mortgages today are 7 to 8%. So if you can buy something with a 3.5% mortgage, or even 5%, you're still going to be doing better than if you have to take new money at 7% or higher. If it's hard money, much higher. So inside of a land trust, one of the biggest objections we would hear from the sellers is, okay, well, I'm going to deed this over to you as the investor or your LLC. And once I do that, I've lost the house. I've given you all my cards. I'm done. And if you don't pay the taxes, pay the insurance, keep it insured, pay the mortgage, it ruins my credit and I have no recourse. So what do I do? And most investors, I will give them this, do pay. Most upstanding investors do pay the mortgage. And if they get in trouble, they will go back to the seller and say, look, I'm in trouble. I can't do this anymore. Do you want to take it? And also some sellers their credit's already trashed, so they don't care. But for the ones who still have good credit and there's no equity left in the house for whatever reason, or just not enough equity to make it worthwhile to sell it, in a normal transaction, they will sell it subject to. And to get around that objection of, well, how do I make sure my credit is protected? We say, fine, we're going to do it like we hide the purchase price, where the seller is the beneficiary initially. No problem. Seller, in the blink of an eye, assigns their beneficial interest in the trust to the investor or the investor's company. However, this assignment of beneficial interest is a little bit different because it assigns the beneficial interest with what it's called a reversion clause, meaning it says that if the investor does not pay the mortgage, otherwise defaults on it, and that default stays open for 30, 60, 90, 120 days, the seller can send a letter to the investor demanding that they catch it up. If they don't catch it up within 30 days after that, it reverts to the seller. And the seller can come to us and say, here's the trust, here's the conditional assignment, here's the letter I sent to them, here's the default letter from the lender. I want my property back. I'll look at that as the independent third-party trustee. I go, yep, everybody's complied with everything. It's now your property. What do you want me to do with it? And they go, deed it back to me because I'm going to work out a deal with the lender. Fine, I'll deed it back to you. It just gives, I've fortunately never had to do that, knock on wood, but we have had situations where the investor died and the family didn't keep up the payments because they're like, well, he's dead. I'm not going to bother. We've had it where the investor has just disappeared, fallen off the face of the planet. And at least this seller had this capability, this consumer protection mechanism built into the trust that they could come to me and say, they're gone, they're dead, nobody's paying it. I need to get control of this property again to protect my credit. Fine, let's work it out. We'll deed it over to you or whatever you want us to do. And it's yours again. Go for it. Do whatever you need to do. So it's a good selling point for these investors who are trying to get over that objection with the sellers, that consumer protection objection.
So just so I understand it, when these subject to the mortgages, are these mortgages that are assignable? Or I mean,
some are.
Maybe you can just clarify where that's coming from.
Yeah, some mortgages are assignable. Like if it's an FHA or a VA mortgage, those are all assignable if the buyer qualifies. However, most investors don't want to go through the hassle of getting qualified for the FHA assignment or the assumption agreement or the VA assumption. So, and of course, any Fannie Mae, Freddie Mac, or other conventional loan is typically not assignable. Those are due on sale. And this is always a risk that we advise the borrower, buyer, and the seller that this could always happen. They could always come in and accelerate the loan under the due on sale clause. And at that point, you've got to do whatever it takes to deal with that. And in fact, I had a gentleman contact me a couple of weeks ago. I've only had it happen twice in about 20 plus years of doing this. I've only had one lender come twice to accelerate the loan. But I talked to this other gentleman who buys a lot of subject to properties, and he had it happen 4 times over the past 20 years. And every time it happened, he either already had a buyer for the property and was selling. He had bought it subject to while he fixed it up. He used his cash to fix it up rather than on closing costs for a new hard money loan and interest on a hard money loan. He just kept making the mortgage payments. And what happened was the lender typically sees that the name of the insured changes to a trust, tax bill changes, something like that, and they catch it and they freak out and they accelerate the loan, which means you have 30 days to pay it off or get it back into their original borrower's name. You have 30 days to do that. If you don't, then they accelerate, which is another 30 days. And then there's another 30 days to 60 days before they actually file foreclosure, which gives you another. So it's a long time before anything really happens to you.
So these were just conventional mortgages and they weren't telling the lender and hope they didn't get caught.
That's typically what most real estate investors do. They buy it subject to and hope they don't get caught. And when they do get caught, they deal with it. In this latest case, he would have just paid them off, refinanced it, or whatever, but he had a tenant in the property. He'd put a tenant in there. He'd fixed it up, put a tenant in it. So he was going to fight them a little bit. You know, different people handle them different ways. A lot of times you can work out a deal with the lender. It just depends on the lender and how they want to take it. I think right now we're going to see more lenders who would be more apt to want to accelerate, because if they're holding a loan at 2.8% and they can get that money back and lend it back out at 7.5%, they sort of have an impetus, a reason to want to accelerate as many loans as they can. So I would not be surprised to see lenders over the next couple of years, while interest rates are high, culling through their loans, trolling through their loans to see if there's any, what I call technical defaults. That's a technical default. It's not a monetary default. It's a technical default. To see if there's loans that they can force into foreclosure so they can get the money back, lend it back out at higher rates, and see how that goes. It also is a factor of how soon after the borrower has taken out the loan. We find that if the borrower sells the property subject to the mortgage within a year to a year and a half after they've taken out the new mortgage, they're poking the bear. The lender's usually going to accelerate when they're that soon. But if the loan's been out there for years, it's very rare for the lender to accelerate just because there's been a change in title.
Joe, it's been a great discussion. Just kind of quick summary here. The 5 uses for land trust that we discussed: money lenders, hiding the purchase price, subject to, asset protection, and passing on to the heirs in sort of estate plan light. Is there anything that I missed there?
Anonymity. I can never say that word. Anonymity.
Anonymity. Anonymity.
That would be about it. I mean, those are definitely the top 5. I mean, I could probably think of more and more and discuss even more and more. I find that the more I talk about them, the more stories come to my head of things I've seen over the past 20 plus years of doing this and things I've heard. And I mean, I could talk all day about horror stories and wonderful stories, but I know time's limited, and those are definitely the top 5 that I would want anybody to know.
Guys want to get in touch with you, how would they do that, Joe?
Best way is just to go to our website, mylandtrustee.com. And from there, you can contact us. You can set up an appointment with me. Also, if you want to call us, 833-4FL-TRUST. And that'll reach us toll free anytime, day or night.
Terrific. Stephen, anything else we'd like to cover with Joe before we let him go?
No, thank you, Joe. We'll put our trust in you, and thanks. We learned a lot, and we'll talk to you soon.
Thank you guys for having me.
And that was Joe Seagle talking land trust. Stephen, what were your takeaways from our chat today?
Land trusts are certainly something for any investor to keep in mind. It's applicable. It's very applicable to some situations, and it can be very helpful to investors.
Yeah, I mean, we talked about 5 different aspects of it, and there's some things in there that I learned that I didn't know about land trusts, particularly the bit about the lenders. So that was something I didn't know about before. So that's certainly something that hopefully you guys picked up some things from the show. And land trusts can be very, very, very valuable tools. And Stephen, Joe was a great guest. Where can our listeners find other great guests?
The place to go is www.investfloridashow.com. Also, download and get the app so that you can listen while you're mobile.
Guys, as always, we appreciate the time that you invest with us each and every episode. And until next time, hasta la vista.
You've just listened to the Invest Florida podcast with Eric Odom and Stephen Silverman. Join us every week for actionable real estate investment ideas, and of course, visit our website at www.investfloridashow.com for more shows and tips on how to earn a cash flow in the real estate market in Florida. While hosts and producers of the Invest Florida show have no reason to doubt the validity of comments of our guests, we do not warranty their accuracy. Please check with your legal, financial, and tax advisors before entering into any investment. Returns will vary from person to person and deal to deal based on unique circumstances. All information expressed in this show is for educational purposes only. Opinions of the guests are not necessarily shared by the hosts and producers of the Invest Florida show.